Is anyone else hearing anything? Can you hear the room?
I'm not hearing anything. It doesn't actually look like there are many people in the meeting room yet, so maybe they haven't actually started.
Okay. Is there a chat function to let them know? Hmm, I'm just,
I don't see the chat.
I can hear you.
but you're online, right?
Yeah, I'm in Vermont. Yep.
Okay. But maybe I should call Casey.
I think that's a good idea. I was going to,
Morning. This is Rep. Anderson. We're just waiting on the co-chair, but everybody on Zoom, we can hear you.
Oh, super, thanks.
This will be a few minutes.
Good morning, everybody. Thank you for coming. Sorry I'm late. I was on the phone with Amy from Farmington River. And but we're glad everybody's here. This is going to be a relatively short meeting. We're going to hear from Deep about their resource constraints for dealing with buffers and then or not. And then we were going to take a field trip, but we're going to not go to Farmington today, Farmington River, because it's wet and Amy is between several meetings. And it's very hard on her today to be the guide. So we were going to take a field trip just to West Hartford, and then you guys are done for the day. So Brian, would you like to, oh, I'm sorry, my co-chair.
Sure.
Has a feeling.
Sure. I'm looking forward to our second meeting. I thought our first meeting was productive discussion that led to consensus on 2 items, which I understand to be, and I'm ready to be corrected, that we would focus on the land adjacent to watercourses, not to include wetlands. And we would not pursue a one-size-fits-all policy. I'm looking forward to hearing from Deep today. I know Deep testimony was based on the original version of HB 7174, and they had a lot of recommendations. Also looking forward to our field trip later.
Mr. Thompson.
Okay, good morning. Yes, I am Brian Thompson. I'm the Director of Land and Water Resources Division at DEEP within the Bureau of Water Protection and Land Reuse. And unfortunately, I missed the first meeting. I was out of the country at the time, but I did go back and look at the recording. So I'm kind of relatively caught up on what transpired there. So, you know, as far as deep resources go, this is a kind of a broad topic that touches on a lot of different programs and initiatives within DEEP. So I represent well, I'm representing DEEP, but my division is the one that implements the regulatory programs. So in terms of Inland Wetlands and Watercourses Act implementation, we do the permitting for state activities and also oversee the municipal wetlands programs. And I will say, I believe online today is Kristen O'Neill from our program, who is the person who is handling the municipal liaison function. So, you know, and even the regulatory program, I will say, goes beyond just what we do for specifically the Inland Wetlands and Watercourses Act implementation in terms of what we're doing to protect watercourses. You know, we're also implementing the Clean Water Act 401 requirements for water quality certification, which addresses, you know, private projects. And so we are heavily involved in regulation, and both in terms of private projects and infrastructure. So we do a lot of infrastructure related permitting for municipal and state roads. We also do energy related permitting. And so these are, you know, tend to be big, long sort of linear projects that may cross wetlands or watercourses in many different locations. And so there, you know, there is fair amount of opportunity for impacts to those resources. You know, and beyond just the resources that we have in our permitting program, we also rely on our natural resources Bureau, wildlife and fisheries primarily, to support the regulatory programs. We spend a lot of time, we work a lot with DOT. We spend a lot of time with our fisheries folks working out DOT projects and potential impacts to fisheries resources, river and stream resources, with their help. And we also, rely on wildlife for natural diversity database consultations and consultations on other impacts that affect rivers and streams and wetland resources. And, even beyond the regulatory programs, we have folks in our water quality program that water quality and quantity programs that are doing work that support the protection of rivers and streams and wetlands. So we really, as I said, touch on a lot of different areas of deep. We have staff dedicated to all of those functions. They are working at maximum capacity, I would say. We do not have extra staff. And so, we would certainly be concerned about the impacts to our ability to implement new requirements. But, I can't speak to how budget issues would be handled or additional positions at this point. That would be obviously a discussion with others. So that's just kind of big picture. If there are specific questions, happy to take those.
When the commissioner had testified in front of the Environment Committee, she had said that she had strong concern in adding riparian buffers to wetlands and watercourses as factors to be considered by the commissioner. And she said the geographic area would be enormous, adding at least 100 feet. This was in the previous bill, to the borders of all wetlands and watercourses. Do you see it that, or does she see it that the agency would be responsible for buffers, whereas some of us on this committee believe that it could be done by the municipals exclusively? Can you talk about that, the difference between if DEEP did it or if the local folks enforce it?
So I think that would depend on how it's implemented. I think there is a fair amount of sort of technical and regulatory complexity to implementing buffers that we really need to work through. As I said, the Wetlands and Watercourses Act is implemented both at state level and municipal level. So yeah, DEEP does have responsibility for implementing the requirements of the Inland Wetlands and Watercourses Act at the state level when we do permitting. So we would have responsibility there. And with the kinds of projects, the linear sort of projects that we're handling, that could be challenging. It would be challenging for us. If implemented at the municipal level, I think we'd have to think about how that's constructed and what kind of additional support the municipalities felt they needed to implement a program. So if they need additional guidance, additional training, additional sort of day-to-day interaction with our staff. We do get a lot of inquiries, both from municipalities and from residents about local inland wetlands issues. So, and complaints. So we do, spend a fair amount of time following up on those complaints and trying to respond to those kinds of inquiries. So I think, adding a new requirement for municipalities is likely to generate some additional need for support from deep. How much I can't say.
And is there a person in charge of inland wetlands right now at Deep? That's their sole function?
So there is a person who is the liaison for the municipal and the wetland agencies, if that's what you're asking. Yes.
Okay, so that position is full. It's
That
filled right now.
position
Okay.
is occupied, yes.
And the commissioner also had this issue with the commissioner had an issue with part of our proposal last year that talked about using wetlands as a riparian buffers as a tool. Trying to find it here. If we were to set aside funds in the Clean Water Act revolving fund for nature-based solutions to incentivize landowners, she had an issue with that. And I wondered if you could speak to that, how we could, because if we're going to incentivize places where the buffer's already been removed and we would like to restore it, we need a tool. And can you talk about that question that came up in the last version of this bill?
I think I would need to take that back to our Clean Water Fund experts. Yeah, that is not my area of expertise. And yeah, I didn't refresh on that particular comment. But I think Clean Water Fund, there's a lot of demand on Clean Water Fund. And the Clean Water Fund staff. So that, may be part of the concern.
Any thoughts from the members? Yes, go ahead, Alicia.
So one of the pieces of the legislation we're working under here was very specific about what resources are put into the inland wetlands program at DEP. I think it's important to understand exactly how much. I mean, I understand that all clean water requirements and all water protection overlaps. However, Section 22A-39, the duties of the commissioner, A through N. Honestly, Brian, I have a lot of respect for you and the people that work in DEP and all of these programs, but I do not see DEP meeting the obligations here. There are a lot of obligations that are not being met because resources are not adequate. Resources are not being put into the inland wetlands program. And CEQ did a report back in, I think, 2008, or it might have even been a while ago, where they have the really good analogy of, and at that time, I think you had 3 to 5 people working in the inland, committed full-time employees in the inland wetlands, that you have 5 coaches for 170 teams. Well, now we have maybe half a coach for 170 teams. And using the sports analogy, I mean, imagine how with no one supporting the training for these teams or being there to consult when there's issues, those teams won't be playing very well because they don't have that support. And so I think it's really important to understand exactly how much we want to advocate for funding and positions to be able to support our inland wetlands agencies, because then we will have, because honestly, I think that's why we have a hard time finding people to fill these seats, They don't have the support. They don't have the training. They're left out there in the field wondering what the heck is going on. And did I just commit a foul? I don't know because I don't know the rules. So I just want to emphasize that. And I have very serious concerns about DEP's meeting their responsibility under the Inland Wetlands Act. And I think he had a sort of.
Yes, good morning.
Alan, go ahead.
All right, I'm Alan Sinscalchi, president of Kakiwek, the Conservation Inland Wetland Commission. So thank you for taking the time to present this morning. We certainly appreciate working with Kristen and Darcy Winter before her. They've always been very helpful to our organization and all of our members. But sort of following up with what Alicia's comment, a lot of our Wetlands Commission members are historically concerned, as well as Alicia's organization, with the decrease in resources. We understand working in the state agency, is very challenging. But on a specific point, now that the bill did go through, that's going to require inland wetland training for all commissioners and staff. We understood that right now you don't seem to have the resources to be able to update the online training. And if anything comes out of this work group and causes a change in the both the ability of the local wetland commissions to regulate wetlands, but also just even if it's an informational change that they should know about, that would obviously require an updating and improvement of the online training. So I don't know if, I know Commissioner Deeks had raised concerns before about not having resources to be able to update the training, but is that something that you and your agency are thinking about trying to do, especially if this, as I mentioned, as this work group comes forward with some additional recommendations and changes?
So I appreciate the comments from both of you. And yes, it is true that we are not providing as much training as we have in the past. Absolutely. We have relied on the online training program. There used to be more sort of in-person training, or even more individualized training, which we probably could do virtually now as well. But and we do not have really adequate staff to support that kind of training currently. We could make some updates to the online training program. Of course, you probably all experienced that the online training program was offline for a while. It's back now. I apologize for that, but it is back. And if the updates are relatively minor, it's not a big lift. If we have to sort of overhaul the whole program, that's a big lift. And there is some additional staff or resource impact just to having to provide the online training to a greater number of people. It's not completely automated. There is some manual work that goes on in providing that program. So I guess, Alicia, to your point, there is, Kristen O'Neill is the person who is our point person for the municipal program. She stepped in for Darcy Winter. Darcy moved on to a different position. Darcy is still with us in a different role, so she does provide her expertise frequently. And we also have folks we have an enforcement section. Folks in the enforcement section assist Kristen when we get complaints about particular enforcement issues. But yeah, in terms of general support to the commissions, it is not what it used to be.
So as you know, we as Kakiwek provide training, especially during our annual conference, but I'm glad to hear that you at least are making plans for the possible upgrading and updating of the online training. And I'm glad you also mentioned the point about just getting the administrative burden that's going to be coming this year when now not just one commissioner or staff person in each commission needs to take the training, but everyone. So it's going to be a huge increase in use of the online training. So I'm glad that you're thinking about that and trying to you know, support that a little bit better. Thank you.
Frank?
Good morning, Director Thompson. Thank you for being here. So looking at the Inland Wetlands and Watercourses Act and kind of dovetailing on what Alan had mentioned, it is wetlands and watercourses. And I'm very familiar with the training. I think it's actually a pretty good program. I'm glad to see that all of our commissioners will have to take it now. I do think that the riparian section concentration of the training could just be increased a little bit better. And I don't know if that can be done in conjunction with UConn or your agency. But right now, as it stands in the regulations, the Inland Wetlands and Watercourses agencies are responsible for the watercourses. So perhaps one avenue would be to improve the training relative to the riparian zones so that the commissioners, all of who will now have to take this training, get that reinforcement that it is, additionally important that these commissioners consider the impacts on the riparian areas. Just wondering your thoughts about that. Thank you.
I appreciate that input. To hear sort of specifically about something we could do to improve the training. And I guess I would say that if others have sort of specific recommendations on improving the training program, we are happy to hear them. We welcome them. We would have to consider, again, I think the extent to which that requires sort of a major rebuild of the program, which is not then just our staff resources. It's also an expense to work with an entity, currently UConn, to sort of restructure the program.
Could that perhaps be done as a standalone program that an appendix, if you will, or an additional separate program? Would that be cost effective?
Potentially, yeah. I guess we'd have to look at that. We'd have to look at what the most effective way to sort of implement that kind of update would be. Yeah.
Thank you.
Thank you.
Hi, Denise Savageau. I'm with the Connecticut Council on Soil and Water Conservation, and I also worked as a municipal official for over 30 years in land use. And I can tell you that the amount of assistance from DEP on all of its programs, as the conservation director for the town of Greenwich for many years, I was often called on to, hey, could you go check out a tidal wetland issue? So relying on town staff. So I think that to say that the town staff and or commissioners, obviously we all need training. As a professional environmental, as an environmental professional, I always want to keep my training up to date. I think we need to do that. But I also want to let folks know that there's a lot of expertise within our towns and they share it with each other. That said, we do need to continue with the training. The Council on Soil and Water Conservation sent a letter to DEP at least 5 years ago. I'd have to pull out the letter and I can share that with you, offering to help them with their training program. Understand that the council is a state agency that includes the University of Connecticut, includes USDA Natural Resource Conservation Service, where the soil survey and our basis for our wetland act is. So we have a lot of expertise on our board, the council, and DEP indicated at that time that, oh, we have our online training and that's enough. And I have to tell you, the commissioners that I talked to, the inland wetland commissioners, as well as other land use commissioners, saying it's not enough. Taking a training online is not the same as having, for example, a webinar where at least you can interact with the technology we have right now. Just having someone clicking onto a video and watching it is not the same as an interactive webinar. And there's tools and there's training that could happen different ways. The way that the training is set up, for example, for zoning officials, and I happen to be right now on my zoning commission in town because I am retired from the town of Greenwich, and now I live in Old Lyme. For zoning commissioners, I can take a training with one of the COGs. I can take a training with Yukon. I can take a training different places. I don't have to have this only training by DEP. And I think expanding the opportunities, because Yukon has wonderful programs that they could do on riparian buffers and other wetland issues. There's the soil and water conservation districts, the COGs. There's a whole host of groups that can do this type of training that could be acceptable. And I encourage DEP to be working with others on this new, looking at what they're going to do for training. By having the training and only having it go through DEP, I think that's problematic because of their lack of resources right now. But also just in terms of there's a whole host of things out there. Why not take advantage of them and do it a different way? So I'm just putting that out there, that I think we have work to do that way. I also want to say that from a riparian buffer perspective, the inland wetland agencies and all the town municipal boards are already looking at riparian buffers. We know we need to do this. We have a mandate under our stormwater permit that we are required to do. And that means looking at our wetlands agencies, looking at our zoning agencies. What are we doing for stormwater permitting? As well as the Inland Wetland Act. Everybody's already looking at riparian buffers. So to say that this is going to be a heavy lift, it's about a new regulation and how to use it. But I look about it at this more that updating the Inland Wetland Act to make sure that we're talking about riparian buffers and allowing it means that you're giving the wetland agency the tool that can't be questioned in court. So that it basically says very explicitly in the legislation, they're already trying to protect riparian buffers, but then they don't necessarily have the tool, or then they get challenged. Giving them the tool to use that and use it correctly I think is really, really important. So I just want to say that to say all of a sudden there's going to be all this new training that's needed on riparian buffers, or that the Inland Wetlands Commissions haven't thought about riparian buffers, is just incorrect. And my last point is that the Long Island Sound Study, which is now the Long Island Sound Partnership, has just updated its CCMP. And in that, it talks about riparian buffers, and that we need to have riparian buffers to protect our public drinking water supply, of the Long Island Sound. We also need them to protect our public drinking water supply. But we have this in more and more legislation and more documents that we should be doing riparian buffers. So I think that the local land use commissions are hearing this from different places. There's lots of opportunities for us to work, and I think identifying those tools, Sustainable Connecticut, for example, is one of the tools that we could look at in an organization that's doing so much work with municipalities and can do some training that way. So I just want to say that, DEP, I appreciate that. The staff I work with at DEP are so dedicated, but they are understaffed. And if we're going to just say that we're not going to give the tools to the local commissioners because DEP is understaffed, I think we're making a big mistake. We have the ability in this state to do this right. And we have the opportunities with organizations like the University of Connecticut, as well as the Council on Soil and Water Conservation, CACI-WIC, Rivers Alliance. We're all here. We can all do the training. We all have technical expertise, and we don't need to have it just fall on DEP. Thank you.
Thank you. Mary Pelletier in Zoom has her hand raised.
Hi, good morning. So I would like to mention that in addition to all of what's just been said, that the cities are really left out of all of these protections, and a lot of the wetland commissions have been merged into planning and zoning, and that's even true with West Hartford, and that's created a lot of pressure for those members of the Wetlands Commission to simply go along with planning and zoning. And for many years, Hartford didn't even have a Wetlands Commission, and I've kind of gotten used to this because when I started this work 20 years ago, I had somebody who worked very closely with the state actually who just said that the Park River Regional Watershed was a quote unquote throwaway watershed. And I think that that for many years was a position, and I hope that you all can see that on the campus of the UConn Law School, there's a salt shed above a bioretention basin that was built with federal money to capture the stormwater runoff, and it's draining into a wetland, the salt. And I've showed that to people from the state. I've showed that to people from Circa, and nobody does anything because it's the city. So I'm not even sure how to address this concern, because it does have to do with staffing, but it also has to do with a position about the development of our high density communities. And once they get to some tipping point of development, uh, there just doesn't seem to be any effort to protect the streams at all. Now,
Thank you.
and I don't want to say it all, because I work with we work on the watershed management plans, but we've just finished a watershed management plan, and I was at a water planning council meeting recently, and I pointed out that just after we finished the watershed management plan, a different division of DEEP had given money for a trails study, but there was no effort in the RFP to say, your trail study needs to look at the watershed management plan. And in a city where everything is converging, you can't have these silos. You have to have your people working together. And again, this is probably an issue of there not being enough staff to function in this sort of synthesis in urban areas, which are very different than other, than less developed areas. And so I really appreciate what Deep's doing, but I also think there's a problematic staffing issue, and it's so evident in cities.
Charles Vidic with the Western Connecticut Council of Governments. I totally support what Denise has said about the other options in terms of training. I've taken the inland wetlands training and authorized by the commissioner, so I'm very familiar with that program. I think it's fine as it is, in the sense that it does provide a basic level, but there's far more that needs to be done today. The science of riparian buffers is totally outstripped the regulatory world in which we live in today, not only in Connecticut, but throughout most of the United States. And that science is not incorporated into current training programs. We need to start doing that. Pervious cover, impervious cover, that whole balance. That's a science which has emerged in the last 20 years and is also part of the 2024 Stormwater Quality Manual in terms of basic concepts. Those issues need to be integrated into our training programs. And I do think Denise has made a very good point. There may be some kind of credentialing that might be needed if the state feels that we need a standardization, that they meet certain standards. But I think there's some real value in doing that. And secondly, since I've also taken the 40-hour Army Corps training, I've been trained in a lot of different environmental programs. That is another important thing to understand. When you take a 40-hour training program, you're not taking a test, and you're not just taking a book review. You actually go out and do a field investigation. And that is a fundamental flaw of what we have here in Connecticut. This is something that's foundational. We have inland wetland agencies, and I'm familiar with what does go on at that level since I've studied all of them. What's going on is they have no idea what a wetland delineation is. Is it a soil-based? Is it vegetation-based? Or is it a U.S. Department or the Army Corps' definition, which is a tripartite soils, vegetation, and hydrology perspective? And they're not really that distinct. I did a study at one time years ago hired an Army Corps person to delineate them using the three methodologies. And the three methodologies are very similar. They're not exactly the same, but they're very similar when you take a given location and look at them. But the point of it is that the field investigation skills are very, very valuable. I learned a lot by going through that process. And honestly, what I've seen in Connecticut in terms of delineation is a failure to properly delineate based on soils. I see delineations that are based upon the vegetation. There's no actually digging of holes to look at the actual modeling of the soils. Now, you'd think that that would actually be going on, but that's not what's going on from what I've seen in many locations. So we have fundamentally a flaw that's going on, which may be a convenience on the part of the wetland scientists that are doing this work, and not necessarily in the interest of achieving the goals of Connecticut's inland wetland regulations. So this is a fundamental type of issue, which is institutional in its nature. And from my perspective, that's one of the advantages. Even Kip Kelsinskis, who is in the training program on the online webinar, is shown doing this. And of course, he was on CEQ with myself and said the very same thing. We need to have a field component to give the Inland Wetland Agency members an understanding of the fundamentals. Yes, go ahead.
Hi, Joan Nichols, private consulting forester. So some of my comments are piggybacking on what I've already heard, especially Denise's. My comments are coming from the regulated community side. So as a forester, I have been before many municipal wetlands commissions working with the permitted use of right language in the Inland Wetlands and Watercourses Act. And I'm also thinking about what the mission of this working group is. And what I'm hearing is that the Inland Wetlands and Watercourses Act does have the tools, or so to speak, or the language to protect riparian buffers. So I don't think that we need another set of laws or another set of regulations or another layer of permitting to protect riparian areas. As a forester, if I'm working on a property that's got a riparian areas in it, I've been working with that for 40 years. And I know what I need to do, and I know how to explain this to a wetlands commission. I think the training, I think perhaps what this group needs to look at, and maybe where our recommendations end up landing, is that perhaps DEEP needs more staffing to do their job, is what I'm hearing. Certainly the training for municipal wetlands commissions, I personally have been beating that drum to have it mandated for years. And the reason I'm doing that is I'm a certified forester. I'm certified by DEP. I have to have a certification. My certification through DEEP has been in place since 1993, and I'm required to do continuing education in order to maintain my certification. And if I don't do the mandated training and certification, I lose my ability to do my job, and that's all regulated through DEEP, and I'm absolutely fine with that. But to Denise's point, there are almost 500 of us that are certified by the state of Connecticut, and we have to maintain our licenses and our certification. We don't rely on DEEP to do all of the training that we need to do our jobs and maintain our certification, including the work we do in the field, whether it's best management practices, working around water quality, or whatever that is. We rely a lot on, there are trade organizations in the state. I sit on one of those boards. We've worked with Yukon Extension to do training. We have worked with Deep Forestry on occasion to do training. So I think, to Denise's point, I think what we're looking at is we need increased education, we need to beef up the training on the municipal side, and we need the funding that DEEP needs to do their job rather than putting on another layer of regulation over our riparian areas, which I understand are already protected under our existing legislation. So those are my comments. Thank you.
Go ahead, Representative Dubitsky.
Thank you, Madam Chair. I am sensing some type of consensus, which I agree with, that we should not have a completely new, separate set of regulations from the municipal end. You know, one could only imagine that if somebody wants to do something in or near a wetland, being told, well, below the high water mark, the municipality deals with it. Above the high water mark, the state deals with it, or, you know, some other entity, and having to try to navigate the two different sets of regulations, the two different entities, when it may be a very simple thing of, you know, just putting in access. Suddenly you have to deal with two different things. Each one is pointing at the other, that they are the ones holding up the project. So having everything together under the wetlands regulations administered by the towns sounds to me to be the best way to go. The second thing is, we also need to remember that in most towns, or at least many towns, all of these wetland agency members are all just local volunteers. They do not have extensive scientific backgrounds or training, nor will they take any. If you require every inland wetland commissioner to take 40 hours of training a year or per term, it will become very difficult to get anybody to volunteer for those positions. So whatever we do to change the regulations, to add regulations, we just need to make it simple. We need to make it simple that regular people can understand and administer, because if you get too scientific and too technical and require too much training, you're going to suddenly have an awful lot of towns that just don't have anybody who's willing to do it. Thank you.
Could we, Representative, I just want to just have no, I just want the members who are already involved in wetlands now mull on that suggestion and whether it's workable or not. If you could comment on that, and then we'll come back to you, Representative D'Amico. I just want to stay on his suggestion, Representative Dubitsky's suggestion, that we can't make it too complicated.
So I have to run out of the room and I will be back. So
Okay.
I just want to, and I don't mean to do this, but I do have another commitment for a short time. So I just wanted to piggyback on what Representative Dubitsky said. So it occurs to me that if we do decide to make recommendations to put some of this responsibility, give some of this responsibility to the local inland wetlands commissions and commissioners and so forth. Someone mentioned, I'm not sure if it was Alicia or Denise, are we, is this responsibility going to result in legal challenges? As Representative Dubitsky just mentioned, these local folks don't necessarily have the expertise, the knowledge, and so forth. So if we take that responsibility and give it to the locals to take some of the pressure off of DEEP, are there going to be legal challenges? I don't know the answer to that, but I think it's worth considering. And I'm sorry to have interrupted.
First, I think it's important to clarify, as far as our Inland Wetlands Act, there are no regulations. DEP has the guidelines that were last published that have not been updated since 2006. I don't think anybody's talking about a complete different set of regulations, but what my goal is to make sure that our inland wetlands agencies have the tools that they need to protect the vegetated areas along our waterways. And that is going to require some clarification in the statute because we don't have regulations. And the guidelines have been forthcoming for a decade now. So without having something clear, and yes, it has to be administered at the town level. That's how we do it. The state, and it is a little bit different, and Joan, than the regulated community, because the inland wetlands agencies, the state has given them that authority. They have taken that responsibility off of them to make these decisions and to administer these permits. That's what the town has to do. So it is important that things are clear so that our inland wetlands agencies aren't struggling. And it should be clear that they can protect the vegetated areas along our waterways. Thank you.
Joanna Shapiro.
Hi, thank you. Representing a conservation district and also an inland wetland commission. You know, I have much respect for Joan as a forester and everything she's done, Farm Bureau and all else. But I have to sort of echo what Alicia was just saying, that it's definitely different. Joan's experience going through the jurisdictional ruling for forestry operations. Yes, the commissions have to review activities within 100 feet of wetlands and watercourses, but as Alicia said, there's no language that's protecting riparian areas, and there's nothing that a commission can do right now to stop development in upland review areas, really, because you'd be hard pressed to find an expert, and that's really the burden that's on the commissions right now, is you need an expert to say on the record that an activity in the upland review area will somehow chemically, physically, negatively impact that wetland or water course. Or if it goes to court, it will be overturned and the commission will lose. Right now, there's no intrinsic value placed on our riparian area whatsoever, and there is no tool for commission. And to say, you know, one shed, one garage is going to have an adverse impact is nearly impossible. It's that whole concept of the sum total of everyone in a community putting a detached garage along a stream or wetland. The sum total of that is devastating to the wetlands. And as was mentioned, there's science behind that, the impervious coverage. But on an individual application basis, it is impossible to make that case that this one structure is going to negatively impact the wetland. The commissions, you know, there's a lot of talk of training. Training is very important, but training alone is not enough. And the commissions right now are frustrated that they're afraid to deny any work at all in the upland review area because it goes to court, it gets overturned. The valuable trainings we get at Kakiwik with land use attorneys reinforce that year after year, that we're so limited in what can be considered for a decision. So right now there's no tool for commissions to really prevent deterioration of those riparian areas.
Kristen, online?
Hi, I just wanted to add a small point of clarification. It's true that the deep model regs were last fully revised and published in 2006. However, the program has published regulation advisories that recommend amendments to towns' regulations. I believe the most recent one was 2016. post-COVID, and especially post Darcy leaving the program and me coming onto the program and sort of learning the ropes, we have missed. I believe 2021 was the next time that legislation was passed that would have affected inland wetland regulations, municipal regulations, and that regulation advisory is drafted and will be published shortly once the review is finalized. Um, so it is true that we have missed the last couple of regulation advisories in recent years, again post-COVID, but that we have published advisories that recommend amendments to municipal regulations since 2006.
And then Mary Pelletier.
So I want to be supportive of what Joanna said about these commissions, because what she's talking about in her experience in more rural areas is what we see in Hartford as well. But the other problem is that the people who are actually appointed to these commissions, especially in cities, are either A, not experts, or B, people who are really pro development. And then, you know, we have to react, the watershed stewardship groups. So in addition to training, you know, one strategy or one issue would be to making sure that the local watershed stewardship organizations have representatives on the Wetlands Commission. And that's often becomes a kind of political thing where they're not included and, you know, they're not recognized as experts. And that's a problem, right? Because then it becomes a political thing of trying to get support and the people motivated on just tiny decisions about that just ought to be based on science and an understanding of what good urban planning is. So I would just like to emphasize that. And then also to say that I think we are all in agreement that deep needs more staffing. And, you know, one of the thoughts I had over the weekend was whether this, you know, whatever we do as a group, it ought not be an unfunded mandate. And so I'm not sure how that's addressed in the policy or the legislation, but I think that if, you know, that we should keep that issue, whether there's stormwater utility funds or somebody mentioned the state revolving funds, but I think that whatever we do as a group, it ought not be an unfunded mandate to the towns.
Good thing to keep in mind. Is there anyone else who wanted to speak again? Oh, Brian.
So thank you. I just wanted to take a step back for a moment and say that there certainly is plenty of science to support the value of riparian buffer areas for many ecological, so, you know, protecting many ecological functions, water quality and habitat. But what I want to point out, and what one of the department's concerns previously was that from a legal and sort of a regulatory implementation standpoint, this is complicated. And I'm not an attorney, so I can't get into the legal complications directly, but I think we really need to think through how anything we recommend here would be implemented to avoid the legal challenges and make sure we're doing it in a way that we can all effectively implement. And we've talked a lot around the municipal wetlands agencies here. I don't know that we should conclude that that's the appropriate place for this regulatory program versus zoning And I know there was some discussion of that at the last meeting, and I think that still needs to be considered and thought through carefully, and sort of work through those complexities before sort of coming to a conclusion on the right place for any new program.
So you're saying that the science is clearer than the law right now, so that.
And I think
too
that was
much-
suggested in an earlier comment too. Yes, that the science has outstripped the regulatory programs.
So we have to catch up, you're saying.
I think we really need to think through the legal and regulatory aspects of it carefully. Yes.
Yeah, because court fights are expensive, they're lengthy, they're unclear to the parties. Doesn't seem like the way to go. But somebody else, I saw a hand. Alan.
Yes, hi. If I may ask the co-chairs if they would permit Attorney Brooks to say a few words in response to some of the discussion.
Been in court enough times on this stuff. I think she's entitled. Can you also address, since you're go to court so often, can you also address this question of, is the science, are the regs caught up to the science?
Okay, so I facilitated the wetlands practice program in the Attorney General's office for 18 years, and DEP was my client and was part of the training program, developed all the legal portions. I have a 4-part training program that I administer through Kakiwik, and also I was funded through a foundation and worked with one conservation district. So number one, I think we hear it. DEEP can't adequately oversee the whole program, so they need to permit and sanction other trainers. Just like I have mandatory continuing legal education requirements. I can get it through the Connecticut Bar Association, but I can go through a whole bunch of other entities that are also sanctioned. So I think that needs to happen. They can't have it both ways, that they don't have adequate staff and we're the only ones who can offer something. Okay. I don't think that the sky is falling because things are receiving wetlands permits in the upland review area. I think people are misunderstanding the upland review area is an area to bring activities in to see whether there is going to be an impact. And I think there's a big difference between something that happens 80 feet away from the edge of a watercourse and something that happens in 10 feet of a watercourse. So I don't find the sky is falling because there are applications for the upland review area. And it is not my experience in over 200 wetlands appeals. I see soil-based delineations every day of the week, all the time. It's happening. That's what the municipal wetlands commissions understand. It's only when you're dealing with folks who do federal agency work that they're not doing it. But it's not a problem because that's the blinders they have on. And in fact, I feel like I'm so grateful we have a soils-based program, because while it may be a tripartite explanation on the federal level to do wetlands, you got to put the fourth category, which is what's the most recent Supreme Court decision. And we don't have that problem here. We have soil scientists who at best may disagree with, does that soil boundary end here, or does it actually extend maybe another 2 feet? You don't really see fights between wetland scientists, and I've been involved in those. That's not where the fighting is happening. It's about the value of something. And I also, just some other things, a full spectrum of people representing the town should be on a wetlands commission. A full spectrum, not just, it's not just a Preservation and Conservation Act. And why do I say that? Because the act says it in the legislative finding, and because Steve Tessitore used to say it to me for decades when I was at the AG's office. It's not tidal wetlands. Tidal wetlands is a Preservation Act. Inland wetlands is a balancing act. So there are a lot of things I'm not as worried about, but some of them that I am is that I think the online training is a good starting place, but it is not a place to end. You got to then get it under your fingernails and really engage in it. And sorry, it has to be live training. You can't. Yes, you can start with online training. Yes, you can sit back and have popcorn while you're doing whatever and answering somebody else in the family and scrolling through emails while you're doing the online training. But you need to be engaged with your own regulations and figure out how to do something. And that's a more laborious online training. So let people who are doing it train people and sanction that. That's to me is a no-brainer. Um, I I am not as concerned that the model regulations haven't been updated since 2006. I have a few isolated concerns, and I've shared them with Darcy over the years, and she has the exact same ones, but they're small. They're not the system isn't the problem. It's getting experienced people, and it's the need for constant training of people because every 3 years or so, folks change membership on wetlands commissions, etc. So courts, is the science not caught up with it? The issue is because we have lay volunteer commissioners, everybody who comes before the commission has to come with an expert or three, depending on, an engineer and a wetlands biologist and whatever else. And it's really essential if an agency wants to disagree to have a third party review or their own experts. They don't have to have staff and they don't have to have engineers on the commission and soil scientists on the commission. But there are ways in the way the act is set up to complex application fees can be assessed. There's statutory authority for small commissions, large commissions that are overwhelmed with other issues, Hartford or whoever else, to use that fee schedule. I come to some training I do at Kakiwik. I went through a whole thing of how everybody can raise the fees necessary to defend their actions, and just for an example, I may think that I do really interesting training and I'm really animated presenter, but what I really know is the reason I get over 100 people at every legal workshop I do at Kakiwik is because people are starved for legal input and going through, working through problems and working out scripts, etc. They can get the experts. I mean, I can to help them figure out how they can do it with their fee schedule. I don't think they need to become the experts. They don't need to put an auger in the ground and do it. But they need to know how to put it all together. So, is the science ahead of the law? I think the statute is elastic enough to support it as long as the commissions employ, I don't mean as a full-time employee, utilize experts, because the folks coming before them, the applicants, are doing that. And the case law is, so since 1980, the Feinstein case, areas of complex, pollution control are complex scientific issues that aren't susceptible to lay volunteer input. Anything of a personal knowledge, where did the flood line go, during X storm, that is of personal knowledge. So in fact, they shouldn't be coming the burden on them shouldn't to become little experts. They don't need to do that. They need to know that they need to look for experts. They need to get the input from experts. They need the expert to explain why the expert for the applicant is satisfactory, it could be better, or isn't satisfactory. And that everyone needs to be able to do that. I worked for I was this town attorney for a small town, no staff, but they had a revolving set of experts that they brought on depending what the case was. and they did great. They were just fine. So, yes, there are legal rules. You got to rely on experts. You got to have expertise in order to support your decision. But in sum, I don't think the sky is falling. I think the statute can work, but there needs to be a lot more training if we if we want to just continue with the municipal approach. And another program that DEEP also does for wetlands, which is in all their dam safety applications, and that preempts municipal wetland authority. So they not only work on state agency action, but also on all the dam safety applications around the state, and they all involve water courses for reservoirs and whatever the reason for the impoundment is. So I've probably gone on at more length. If you have any questions, I'm happy to.
Well, I'm just trying to get back to what Charlie said, which is that on the protective purposes of a riparian buffer are not recognized, I guess, in current law.
Well,
Because if you
there's
talk
no
about
standard
soils,
in it. There's no standard in it, right?
Right.
You'd need an expert each time, but every wetlands biologist I've worked with knows the values and functions of a riparian buffer. So if they're brought in on a project, they tell you that, or if they represent the town, or if they're a third party. A lot of towns use third party reviewers. They tell the town. I don't think there's a problem with wetlands biologists knowing that and being able to provide that on a case by case basis.
Okay.
So what the problem is, so if you don't want one size fits all, then you have to, in the statute, already go and figure out what those different sizes are. And, given the different sizes of lot sizes, then, 100-foot vegetated zone is one thing when you own 40 acres. And it's another thing when you're on a quarter-acre lot. It's going to be the whole lot. So
Yeah, Denise. Yeah, thank you. So I think the idea of looking to change the Wetland Act and why we need to do it is about making sure that there is no ambiguity. And I understand that in some of the upland review areas, legislation, when it has gone to courts, it can go one way or the other. And one of the things we have in a lot of municipalities is that we don't often have legal advice going to the commissions from the town attorney, who are often, more labor attorneys or have other types of expertise. They're not as proficient in land use regulations as, Janet is, or some other folks. And so they give them advice a lot of times that's like, just keep out of court. I think our job here is to say, like, can we make sure that with what we know now, with the science of not only riparian buffers, but the science of resiliency and the nature-based solutions that we know, and that's what riparian buffers are. Does the statute make it clear so there's no ambiguity? Because that's the challenge when you talk about the Clean Water Act and wetlands protection, and the sections that deal with wetlands, and that is the ambiguity. And what we think would be really good in this particular act. Because everybody's saying, like, oh, you're changing jurisdiction. I think it's a matter of making sure that the commissions have the tool, as Joanna was saying, so that there isn't any ambiguity. It isn't about that you then have to always have an expert come in. If we know that riparian buffers are good, and we say that in the act, that that we are going to protect these, however we add that language in, that gives the commissions the comfort level to be able to make the right decisions and not feel that they, can't do that. And one of the things that happens is you can have, one legal expert on one side, and then a third party come in for the town, and you can have them have conflict in reports. because people say what they want to say, in terms of reports. It's interesting because I've had some people who are, if they're working for a developer, it's like, well, riparian buffers are okay. If they're working for, an environmental organization I've hired, it's like they're the best things since sliced bread. So, we can get reports like that, and we have to, and this is the thing that commissions have to do. And I also want to just make sure people understand, because people start talking about like wetlands. Right now, we're talking about the water course as part of this legislation. So it's not about wetlands. It's not about the soils definition. That's about the training part is all important, and healthy soils in riparian areas is important, but they're not usually defined by wetland soils in riparian areas that are in the upland review area. Otherwise, they're protected as wetlands because we have, the floodplains and whatever. So we're talking about things that are in the upland review area that are not classified as wetland soils when we're talking about things along water courses. Otherwise, they're already protected. You're absolutely correct. So it's this upland review area that we really need to be protecting. And those are the areas, and for all of the reasons that we know, riparian buffers are important. So I just want to say, like, the idea is to make sure we don't have ambiguity in the law, and let's take a hard look at it and make sure that it's what we need it to be.
Maybe he's at sea. Bill, Lucy, are you there?
I am, but I believe Joanna was before me.
She previously spoke. We'll get back to her.
Okay.
Speak
Okay.
next.
Yeah. So I'd just like to address the comment made by Representative Dubitsky, and I think it was just answered really well. So I was going to say basically the same thing, but I think he's absolutely right that whatever we do, and Denise used the word ambiguity, and that's what we've been dealing with for a long time. You could drive anywhere in Connecticut and you can see all sorts of compromised riparian areas right from the road. I mean, it's a real problem. So I think if we can make it simple for the municipalities to have a minimum standard, I think that's what we're talking about. As Denise said, we don't want to be going down the wetland rabbit hole right now. With the federal issues and all of that, we need to focus this working group on that question. We're looking for revegetated buffers. Even if it's a minimum vegetated buffer, it may not follow the science, but it's going to put a clear line of where we start. If you want to make it bigger, the upland review process, that may be the appropriate place, but we need to stop folks from mowing and clearing right down to the banks of our waterways. We just have to stop doing that. And I know a lot of people don't do that, and some municipalities are doing a great job, some aren't. We need to make it easy for the commissions and very simple with a tape measure, regardless of soil definitions or any of that stuff. Have a minimum standard, have them graded like they've been done in other states, where to the point of we've high density housing where, if you put a 100-foot buffer in, yeah, you're going to include the house. Can't have that. That's obvious. So we would have a series of simple distance measurements. That's a starting point for the upland review area. I think we need to focus this. If we're going to try and get this done by the next legislative session, I think we really need to stay away from that wetland rabbit hole right now. So that's my comment. Thank you.
I appreciate your saying that, because in my town, the town is actually harsher on some of the applicants than it is on its own property. They cut down buffers in order to see the water. It's strictly for views. That's it. And they ignore the filtration abilities of the buffer. So if we could fix the ambiguity, as you said, I think that would help a lot. That cutting everything down is a bad thing. Leaving some material there to grow and filter is a good thing. And, just simple, easy to understand. But Joanna wanted to speak too. Joanna.
Hi, sorry to talk again. I just want to clarify a bit, and I agree with everything that Bill just said. Want to clarify and speak to what Attorney Brooks said. For large applications where it's complicated, it's a huge development, it's a commercial project, whatever, yes, you may involve experts and the towns can hire their own expert. And that is probably done a lot of the time, not all the time. Still may be a little bit challenging to make the case for riparian buffers, but it's that death by a thousand cuts where you're not going to hire an expert every time someone wants to put a gazebo right on the banks and clear all the vegetation. And even if you did hire an expert, getting an expert to say that that one activity is going to adversely impact that whole wetland system is a losing proposition. It's that recognizing that science that says removing all these riparian buffers, the sum total is such a devastating blow to our water courses. You can't get it done with our current statute. You need that clarification and remove that ambiguity. And as Bill said, put in minimum vegetated buffer requirements, or otherwise you're just never gonna get there where there's all these small individual applications that are just eating away at all those riparian areas. You need something concrete that acknowledges the science that these riparian areas are crucial, or they're just gonna continue to disappear.
Representative Bill.
Yeah, thank you. And yeah, I just wanted to follow up a little bit on what Bill Lucy and some of the others have said. And I agree wholeheartedly with the need for simplicity to the level that we can make things simple as we move forward. But I do want to mention a word of caution, and that's that things like minimum standards and starting points over time have a way of morphing into the viewpoint that you're doing all that you need to do in every instance. And so just a word of caution that there is a danger with minimum standards and starting points, that we, in addition to that, need to make sure that the system, while maintaining its simplicity, is still robust enough to meet the intended conservation needs.
So you're saying, in essence, that if we say you have to have at least 10 feet, that towns may just revert to the 10 and not, and then in some areas where they need 50, they're not going to do it.
Exactly. To save
Okay.
time and over time, 10 will become not just a minimum, a starting point, but will become a standard beyond which nothing is necessary, no further thought, because thought takes time and effort.
Bill. Oh, excuse me, Doug. Excuse me.
Thank you. I'm a little concerned about the discussion about minimum uncut areas of vegetation. Because if you think about, you know, that would mean every lake, every river, every pond in the state would have, let's say, you know, 10 feet or 25 feet, whatever it is, from the edge of the water that you couldn't touch. So there are a lot of lakes in this state that have lake houses on them. So every single person who owns a lake house will now no longer have either access to the lake, or at minimum, they will no longer have a view of the lake once everything grows up. There are businesses, there are restaurants, there are hotels, there are all sorts of things that rely on their ability to see and access lakes, streams, rivers, ponds. Just saying, okay, everybody has to stop doing everything within a certain distance from the water's edge. You know, that's a taking. That's a big taking. That's a big fat taking. And if I had a little lake house and the state told me that I could no longer get access to the lake, or could no longer cut my lawn, and I could no longer look out my back window and see the lake, I'd be pretty unhappy. And I'm sure there are an awful lot of residents, citizens, businesses that will have that same problem.
Charlie.
Yes, if I may speak to that point. As I mentioned before, I've reviewed all 50 states, including all New England, on these types of issues. And it certainly is an important point that you've mentioned. But they have all been dealt with in other states. For example, non-conforming scenarios are explicitly mentioned in the Massachusetts River Protection Act, with all of the caveats for existing nonconformities, and with explicit provisions for allowing people to do certain things that already exist. So those kind of issues, which are important to deal with, obviously because of the taking issue, there's no question that has to be dealt with. That's fundamental. But the states that have done it, particularly Massachusetts and New Hampshire, have very explicit ways of dealing with these issues. And I would suggest New Hampshire has a pretty good approach. New Hampshire's approach is they allow municipalities to have riparian protection programs, but each program is reviewed and approved by the New Hampshire Department of Environmental Services before they go forward. So it's a review process. And if the state says, yes, you want this particular river to have a riparian corridor, then we want to see what your proposed approach will be. And then in that approach, there is a review process. And then once that's done, then there are regulations which allow for the addressing of non-conforming issues and a variety of other approaches, but with a catch that the state reviews each proposal to do these things as opposed to a one-size-fits-all approach. And it's actually worth looking at, in my opinion, as a way to have the flexibility because, like I mentioned at the last meeting, Greater Boston has a 25-foot setback for the Charles River, for example, because it doesn't make sense to do anything otherwise, with exceptions, of course, because of nonconformities. And then the rest of the state is 200 feet. And this is all part of the law, not the regulation, the River Protection Act. So there's ways of doing this. And I think it's important. You have to do exactly the acid test is, are you taking people's property by what you're doing? But then on the other hand, are we at the same time not considering the fact that we're taking other people's property downriver by not taking care of the river protections, which destroys the other people's houses because of flooding and mismanagement of stormwater? So there's a balance here that we have to think about. The balance is that we are actually adversely impacting everybody downstream of the border with Massachusetts who doesn't take care of compensatory storage, for example, reduced pervious areas. All of those things are a balancing act too. So we have both the challenge of protecting those downriver, and we have the challenge of protecting the property rights of the individual. Now, the other states, and I've looked at them all, have dealt with this issue, and I think that's not really the issue. The really issue, in my opinion, would be deciding what's the purpose of having a riparian buffer zone. One of the purposes, in my opinion, is that the wetland regulation isn't the issue at hand here. It's the watercourses and the concerns with flooding, for one, stormwater management, which is a quality and quantity issue. And of course, you're dealing with the nitrogen and phosphorus issues, which the state is under a consent order to reduce nitrogen and phosphorus with EPA, which also has to do with the adverse impacts on our Long Island Sound. So I think those issues can be resolved, and it's very clear from what other New England states have done that it can be done, but it's a two-step process. One is having a law, and second, really, to do it properly, is to have a regulation that implements it, because between now and January 15th, we will not have time to get into the minutia of writing that. That's normally the two-step process that goes on.
Charlie, in Massachusetts, do they have enough people at their deep to handle the non-conforming uses by the municipality? Because if we do it the way you're suggesting it, we already heard from Deep, they don't have the staff for that.
Well, they've delegated the program to the municipal level, and they all have to be as stringent as, but they can be more stringent from the baseline regulation. So the question is, how many of the municipalities have not adopted the regulation? The municipalities have adopted the regulation. And in fact, that's in our report on, the case for riparian corridor protections. We've identified what's going on. All the states have done it. In Maine, they have a program which the state does run the program in a number of areas, particularly the boondocks of northern Maine, where you have plantations and places where they don't have the resources. But basically, they're being run at the municipal level in New England, except for Rhode Island, where the state has decided that they will run the program because of as I mentioned last time, the mission creep, because the local governments were not adequately protecting the resources. So that's basically a little perspective on that matter.
Is your report posted on our website?
I would have no idea because I haven't checked the website.
Okay. Can you check with Casey? We have a guest clerk today from Public Health.
Yes, I did send it to Casey last week. So
okay, because if he could post it, then we can all access it. That's good.
yeah, I don't know if he has or not, but I'll make sure he has.
Okay. And Frank was waiting to talk, and then we have folks online as well. And Joan was waiting to talk. Okay.
Thank you very much. So I've heard a lot of comments, and I just have been making notes here like wildfire about some of these things. I guess I'll start with the fact that I think what Charlie has alluded to and Representative Davinsky, you have to have some level of flexibility, and you have to have some latitude. And the good thing about the municipal agencies, which is Charlie mentioned, some of these states are assigning it to the municipals because just like Connecticut, they don't have the resources at the level of the DEP. That latitude rests in our Inland Wetlands and Watercourses Agency. Now, the statute, is wetlands and watercourses. Should we add the word riparian in there? Probably, The other thing I would say is learning is a curve. Nobody expects, they are volunteers. Nobody comes into an Inland Wetlands and Watercourses Agency and is a scientist in most cases. There are some engineers, and so, there are some people that are. But we need to go down the road of the training aspect, particularly for the riparian segment of this. We've got a good start with the training programs that commissioners are going to start taking in the wetlands realm. I've been, like Charlie, to the 40-hour special where you're digging holes and everything else, and that's great. But you can't expect volunteers to start there. The other thing is, as far as having people on the Wetlands and Watercourses Agency that can help reinforce the value of the riparian areas, every wetland and watercourse agency has to have somebody who has had the training and is certified. So yeah, at least one. So, I mean, it's not optimal, but it's a start. And as they start getting that training, you'll have more than that one. And then I think we look at, okay, maybe you need one that has been through the whole, the large scale training on a wetland and watercourse commission. The other thing I want to mention, and I heard this from, I think, Denise, there seems to be a lot of confusion between the upland review area and riparian areas. And I think that's one of the difficulties that what we saw in the last writing of the regulation. You can't really combine them. They're separate. They're different things. Inland wetlands and riparian areas, the distinctions are significant. You can't say so many feet from one is the same as so many feet from another. And I think that was one of the issues that we had. And I hear people talking about riparian areas and talking about upland review areas like this is, one and the same. They're not. Okay. The other, I'm looking at my notes here. The other thing I'd like to say is I work with the regional, our regional river cog agency. And so that's 17 towns. And I work with some of these inland wetlands and watercourses agencies. I'm on planning and zoning. And I can tell you that when an application comes in, say somebody wants to put a gazebo in. Well, first of all, they need to get a building permit. So they go to town hall, they get a building permit. They need a zoning permit. So they get a zoning permit. That zoning permit won't be signed off on unless there's an inland wetlands and watercourses approval. It's not like they can just walk in and put a gazebo 10 feet from the water. Because as soon as they go to town hall, the building inspector will say, oh, okay, you need a zoning permit. You need a zoning permit. The zoning enforcement officer or the town planner will say, well, this you need to go to wetlands with this. That's typically what happens. That's the course. Let's see if I have any other notes here. I guess that's pretty much what I wanted to touch on. There are some protections. We have an opportunity to increase those protections, but we can't just blanket say, okay, it's so many feet and that's it. And even the exceptions, I mean, Representative Dubinsky mentioned some, but think about this, security fencing, marinas, beaches. You got municipal beaches that are by the water. You can't, I mean, it's a beach. You can't really leave a riparian area. So there has to be some sense of balance, and what already exists is the flexibility that inland wetlands and watercourses agencies have, and they do it every month at their meetings. I see it myself. They look at every application and they try to determine what is in the best interest of the environment. So thank you.
Pretty thorough explanation. Joan.
Yeah, so I'm always guilty of being way too practical. But I just want to make sure that we also recognize the enforcement aspect of this, because you can write all the laws in the world and all the overlays in the world, and if they're not enforced, they don't mean anything. And I had an opportunity this past Sunday to take the Connecticut River cruise from Essex upriver, and it's really environmental, nature-based. You look at the birds and all of that. And I didn't get very far from Essex, and lo and behold, there's this woods, and then this battleship of a house built like 200 feet away from the river. So it wasn't a little quarter-acre cottage with a brand new lawn right down to the Connecticut River. So we could write all the laws in the world. Now, it's my understanding there's something called the Gateway Commission that's supposed to oversee whatever happens along the embankment of the Connecticut River. So again, we could write more laws, but how did this happen? I don't know how this happens, how you clear cut and build a lawn right down to the Connecticut River when we've got the Gateway Commission, building permits, wetlands permits, conservation commissions, on and on and on it goes. So I just want to make sure that we also we have to recognize there has to be some enforcement of these laws.
Yeah, it may just be as simple as what Charlie says, is that the law has not been updated to the science. It may be that simple.
I don't know, somebody clear cut down to the Connecticut River and put a lawn in. I got a picture of it.
No, it's what we don't want to see, because the more people do that, the worse the water gets. So we had a couple people online that were, yeah. Cynthia Rabinowitz online.
Thank you. So I currently work at Northwest Conservation District. I am a soil scientist, soil and wetland scientist, and I have been practicing in Connecticut for 45 years, the last 7 with Northwest Conservation District. And prior to that, I was a private consultant working all over the state. To my knowledge, and Joanna and Denise might be able to correct me on this, I think I'm the only soil scientist currently working for any of our 5 conservation districts. I know I have been asked by a couple of our sister organizations to help out on occasion, and I'm happy to do that. Part of my responsibilities at the Northwest Conservation District is to be on call for any of our 34 towns to help them interpret wetland delineations and various other matters that come into them with applications. And I can, as time allows, sometimes help another district with that. So having been in the profession this long, I remember the days when I was newly working as a professional in this state, and DEEP had soil scientists on staff in their Inland Wetland Bureau. And they were extremely helpful to those of us in the field, helping us to interpret the regulations and various other matters having to do with inland wetland soils from the technical perspective. We don't have that support anymore from DEEP, unfortunately. And of course, the economics of the whole situation is part of that. But I would like to put that out there as something that I feel is very important in this arena. Many of the comments that I jotted down that I wanted to say have been covered by other people, but I do have a couple of things that I want to mention again. And so I believe that we do need statewide regulations and implementation guidance. I don't think that we get uniform application or interpretation sometimes from town to town, and that's something that needs to be addressed. I also think that any regulations that do come out of this effort should accommodate the urban areas with the smaller lots, the suburban and the rural properties. That's something that's been talked about a lot here, and I do think that has to be addressed in whatever regulations come out of this effort. I also want to point out, there seems to me some of the conversation that I've heard, it seems that there is a little bit of a confusion, at least in my mind, that people have between the value of riparian buffers along watercourses, streams, brooks, rivers, etc., intermittent watercourses, and wetlands. So from my perspective and my knowledge, having worked in the field, the ecosystem services of wetlands, even though we do recognize that those are not watercourses necessarily, the ecosystem services of wetlands protect the downstream water bodies, watercourses, lakes, ponds, and flowing water, rivers, etc. So I think that we can use the term riparian buffer equally as important for all of those natural systems, including wetlands. I wouldn't like to see wetlands separated out from this conversation as something special. And the other, following on from that, is that in my experience and my understanding of the science, even a narrow area, 10 feet or less, even in some cases, of vegetated growth around a wetland or watercourse can significantly improve the health of that ecosystem. It doesn't have to be trees, for example, that block the view, especially when you're doing retrofits on properties where there may be already an established lawn from an existing house, and having those roots in the ground, having vegetation that you can maybe see over and keep your view is better than nothing. And, I don't want to get too far into the weeds, no pun intended, but to, go too much into the science. But I do believe that that is something that can be considered as well. Also, my last comment, because other people have talked extensively about other things, I feel that the design community, the landscape design community, has a role to play in this discussion. In my experience, working with private landowners to do wetland delineations. I often come into contact with their other professionals, landscape designers and landscape architects specifically, not to mention, and also engineers. But I feel that the design community, I humbly say this, isn't as tuned in to the need or the regulations for protection of the riparian areas. And so if there's a way to educate that profession, perhaps have some of their leaders from the statewide organizations be part of this discussion, I think that would be very helpful, because I have run into many, many occasions where homeowners and landowners have received recommendations from their landscape professionals that are not in line with what we're trying to do here. So I also want to thank Janet for raising the flag for the soil scientists in Connecticut, and for Denise, who has explained what the conservation districts are doing and what we could do more. And Joanna, my colleague, has explained a lot of the things that I would have covered myself. Thanks very much for this opportunity.
Thank you, Cynthia. We had somebody else with their hand up, Alicia.
I want everyone just take a moment to picture in your mind's eye a lake surrounded by wildflowers, trees, low-growing shrubs, people out on the lake, kayaks, swimmers out by their docks, because they obviously still have access to the lake. And, you know, people mowing their lawns behind all of these wildflowers because no one's preventing anyone from mowing lawns. And picture that scenario in your mind. And then I want you to picture a lake surrounded by houses with green lawns all the way down, and the lake is the exact same color as all of the lawns. And some of the houses are boarded up because the people that it could afford to sell and move because their property values tanked have already moved on. And then there are the houses where the people are still living there, where it's fenced off from the lake because they don't want their children and pets to be in the water because it's toxic. And, you know, we can't make it sound like we have to have one or the, it's what we don't want is the latter. And what we're talking about is reasonable and not, it's making sure that people have the enjoyment of the lakes and people continue to, their property value continues to increase or remain stable because of the work we're doing here. That's why we're here.
Kristen O'Neill?
I just want to take a step back for a moment, echo what Brian said, and emphasize some of Charlie's points. If the goal or one of the main methods that we think we're going to protect these riparian areas is implementation of stormwater standards, impervious cover, FEMA, NFIP standards, compensatory storage, that those are all programs and standards that in Connecticut are primarily, they don't fall under the Inland Wetlands and Watercourses Act. Those are zoning. Standards. And one of the differences between our law and Massachusetts law that addresses wetlands, and forgive me, I don't remember their acronym off the top of my head, but their law specifically states that and identifies that flood risk and stormwater management is a public interest that is tied into wetlands, but the Inland Wetlands and Watercourses Act does not do that. And so again, just to, and I also missed the first meeting. Apologies. So I know that this has been talked about, but again, to really consider what the appropriate vehicle for this implementation is, and whether it's under zoning or with the Inland Wetlands and Watercourses Act.
Thank you. And that's going to come up heavily in the next meeting. We had somebody else on there, Mary Pelletier, and then Doug.
So I'm so grateful for Cynthia for mentioning design, because I have to point out that flexibility is really dependent on design decisions. And those design decisions are really very subjective with respect to the economy du jour of the municipality that's making the decisions. And that's why we cannot assign these decisions to each municipality in fragments. We have to look at whole watersheds. And it, as Charles pointed out, and also Alicia in her own, with respect to lakes, whatever one bad actor may do can affect a whole community and reduce their property values. And there's no dispute about that. We've seen it happen over and over again. So how do we create that flexibility in design? And I have mentioned this idea that you have percentages of within the watershed and along the riparian zone, the riparian area that can be developed. And maybe there's some cap and trade or some, mechanism for access to the water, but at a certain point you've tapped it out. And I realize that may or may not exist, but it is insufficient for people to assume that cities can have very minimal buffer zones and upland areas have 200 feet. We need to create flexibility throughout the watershed and allow people in cities to have healthy stream corridors as well as people in the upland communities. And I could give you examples about the percentages of stormwater that are being sent down from the upper communities into Hartford, where Hartford is now, there's 3 8-foot in diameter outfalls being proposed on a like 5-mile segment, but it's really within probably 2 to 3 miles. And most of that stormwater runoff is coming from the upstream communities, the upstream municipalities having made decisions to approve big box stores and ongoing development that is coursing through Hartford's communities and destroying property values as well. So maybe there's a subgroup that works on this issue of the numbers, but I've seen these graphs where it's like once your development gets to a certain point, the water quality goes down. And so that is my take on this idea that we should assign each municipality to their own set of decisions.
True enough. And I was at University of Hartford one day for a presentation, and it suddenly started to rain, and people started to come out of the building and try to move their cars, and they could not move them because the cars started to float. So they were in the cars, and as you said, it was from upstream, but it happened very quickly, and people were floating away in their vehicles, and then other people were trying to lasso the vehicles and pull them ashore. It was pretty scary. But it's in your case, in Hartford's case, your problems are magnified by whatever's going on upstream of you and sending the water down to University of Hartford. So I did get to see that directly, and it's pretty scary. So
it's a combined, thank you for mentioning that problem, because it's a combined effort of those floodplain parking lots being approved, many of them before 1970, before these acts became around, and then Hartford not having a wetlands commission for many years because people assumed that it's only the uplands that we need to protect and who needs to bother with the cities. And so you're right, there's sort of a double-edged sword where people are now in danger because they've approved these these developments or simply parking lots in a floodplain.
Representative Dubisky.
Thank you. In this discussion, I just want to make sure we don't lose sight of the fact that an enormous percentage of the lakes in this state are man-made, and many of them were designed and built specifically for the purpose of having houses around them. So not every body of water is a perfectly natural occurring thing that needs to be maintained in its natural state. It doesn't have one. They were created for the purpose of having houses around them. So obviously we need to keep the water clean, and the people who live around those lakes have an interest in doing so. I have not heard any news reports of toxic lakes in Connecticut. Perhaps I've just missed those reports, but people do have an interest in keeping the water in the lakes that they live on clean. So, let's just as we're trying to come up with a solution. First off, I think we need to find out what the actual problem is. We've heard about this science that is ahead of the law. I haven't seen the science. What does the science say? What does the science say the actual problem is? And once we know the actual problem, perhaps we can fashion a remedy that addresses that problem without any without overdoing it and without coming up with a broad universal solution that may or may not address the problem. Frankly, I actually thought we were going to, this group was going to start with what the problem is, as opposed to start with what the solution should be. Well, if there is science that says there's a problem, let's see it. Let's discuss it. Let's discuss how to address it, as opposed to starting with the solution and trying to back into finding the problem. Thank you.
Well, we could do that. Most people here know what it is. It's nutrient loading and higher temperatures. But if you want a briefing, we could add that. But it'd probably be just for you, because I think most people here are familiar with it. Charlie?
Yes, to that point, I decided to look at what the problem was in all the 5 states. I have a list of the purposes of the 5 riparian buffer regulations and laws, I should say. And of course, you've mentioned some of them, but there's a lot of commonalities that exist in these, and flooding is one of the issues. They even go into wildlife habitat as another issue. I can just give you some examples from Maine. Prevent and control water pollution. That's one of the most common of all the 5 states in New England have taken that as one of their reasons. Then, of course, you have others: conserve natural beauty and open space. Only a few have that. And you have conserved shore cover. That one is more common amongst all 5. And that's another name for pervious cover issues. It's a word that came in early, but the states that came in later with these, such as Vermont, have explicit standards for their purpose as being dealing with the impervious cover issues around lakes and rivers. I can give you the whole list of what the 5 states have done on that, but there's an extensive number of them. And the commonalities are there too amongst all of them, as we just heard. So I would recommend that as one thing, and I could share that list. You can go look up the statutes that I'm just mentioning if you don't believe me, but that's basically one way to look at it, other than right here looking at, we know from our own personal on the ground experience. But New England is not that different in terms of facing the same basic issues. So I highly encourage you to look at what the purpose is that the other 5 New England states have done. And I think that will shed some light on this subject. Go ahead, Charlie. Go ahead.
Thanks, Mary. So yeah, a couple things. I think some folks, maybe most of us, are struggling with what exactly these riparian buffers are supposed to be. So I think it might be helpful to actually gather and share some photos of riparian buffers actually in operation in different use cases, whether it's residential, whether it's commercial, etc. So we have a sense. I don't think it's necessarily speaking to areas of unmanaged wildness, right? These can be very well managed and maintained areas that are serving a conservation function. And, I think I would certainly benefit from seeing some of these photos of what they might look like in different circumstances. And I also just, to Representative Dubitsky's point, just did a quick Google search and brought up a Connecticut state website that actually has a 56-page list of impaired water bodies in the state of Connecticut. So there actually is a real problem here that needs to be addressed, and I'm happy to share that with the clerk as well so folks can review that. Thank you.
That's good. And Bill?
Yeah, I just want to follow up on what was just said, the mention of photos, and this has to do with the field trip item that's on our agenda for today and going forward. And I was wondering if the chairs would be open to the idea of virtual field trips. And I'm asking that because the field trip that I have in mind could take a long time, even though it's nearby for the whole group to get out there. Whereas I think I can cover it in 6 slides in 10 minutes. So, okay.
No, we were going to do one today because I thought this was going to be a short discussion, but we got into next agenda a little bit and it sort of carried over. But that is actually a really good idea to have individual people that know their sites can go and talk about what the site is doing and how it's filtering out nitrogen, phosphorus, and how many feet they used and all that. We could do that individually and then bring them in here and show them to everybody. Now everybody just woke up here. We have
but also videos of the problem and photos of the problem areas.
yeah. We could do it visually, the modern way. Denise?
Yeah, I mean, I appreciate the comment from Representative Dubinsky because I think it to make sure everybody is on the same page. And Yukon Clear has done all of the work on this. These are the scientists. They have all the work on, impervious cover versus natural cover. They now have a new online local watershed assessment tool that's looking at that. And I think asking them to come in and do a presentation so that everybody is talking on the same terms, everybody knows the science, have them come in and, for the 20 minutes or 25 minutes or however long you want to give them, because they have all of the information. And I think it would be without it then having to be like, okay, what's my expertise here hat that I have on? Have a Yukon Clear come in because, they're the ones who have done so much of the research and so much work on this. So I appreciate that, it's like, here's the science, here's the starting point, and this is why we need to do this.
That's a great idea. Is that okay with you? We'll bring in Clear. Okay, so we'll do that on a future meeting. And then we have.
Well, I'm not Martin Heft, as you can probably tell.
I was trying to figure out who you were. The sign says something else.
My name is Rebecca Dahl. I'm a planning analyst for OPM. I'm sitting in for Martin Heft today. Okay. I do want to bring up, I think that there may be some benefit too in discussing some of the economic benefits of riparian buffers, because that's something maybe we're dancing around a little bit. We're talking about issues with water quality and nutrient load, but we're also talking about issues around flooding, and flooding of houses and businesses and the sort. Those are issues that if we're not paying attention to them now, we're going to be paying for them later. So I do think that may be a benefit to bring some more of that information into the group, but I also wanted to highlight the fact that this is an important topic to consider on a state level because all of these issues are compounding and will come back to the state at some point.
OPM have a person that could speak to that? Or would Claire be able to do the flooding as well?
In terms of like the specific economic benefits, I'm not sure that OPM does have the expertise for that, but I would think maybe UConn would.
If we could ask UConn Clear if they can also address flooding. I don't know if they do either.
And I'm happy to ask around as well.
Yeah, but if you could recommend someone to our clerk, that would be helpful. And then we'll all be on the same page, which will be a good thing. William.
William Henley with the Regional Water Authority in New Haven. I just wanted to bring this back to the beginning where we were asking about DEP's capabilities. And I think one of the really great documents that was supplied to us on the working group website was, I think it was the Inland Fisheries Riparian Buffer Position Statement. And this kind of gets back to Representative Dubinsky's question about, what is the problem and what is needed. I think that was a really great literature review document that was done in the 1990s. And I think updating that with some of the modern science, because obviously some of it's dated, some of it's still relevant. I think that would be a really great resource for us to have. The Office of Legislative Research, they provided a document that looked at the legislation that's out there. I think we also need to kind of look at what the new research is and have that in a document. And I think that document was really concise, really worded towards what, kind of natural resource management objectives DEP was looking to get. I don't know if that's something that DEP could update for us or if that's something that we have to look at in another way. I also did want to touch on, it was mentioned that, the majority of the large water bodies in the state are man-made and created for housing. There's some truth to that. However, I think it's also important to note that the majority of the large water bodies in the state are owned by DEP and they're owned for the public good and public recreation. They're not owned by those people that have houses on the shoreline. And beyond that, a lot of these artificial water bodies in the state are also used for public drinking water supply. So the majority of the large water bodies in the state are actually for the public good and either owned by public entities or utilities for drinking water. So I just wanted to add that comment.
Can you repeat what the name of that report is?
It was the
report?
Inland Fisheries Riparian Buffer Position Statement by Brian Murphy.
Okay.
I believe it was based on the references. It was a 1990s document.
I think that's already on our site, isn't it?
It is, yeah. But
okay.
I think, 1990s, that's 30 years old. I think they could use some updating on some of those, some of those. I did look at some of the citations and, they're still relevant, but updating with current science, I think would be a really great asset for this group.
Okay. Who else we have?
If I may say, I did provide, Casey, a 6-page bibliography of riparian buffer literature on the science and the legal issues connected with riparian buffers, which represents the literature from about 1996 to 2023. So that may be useful, and there's more to it than that. There's actually thousands of articles in this field. It just mushroomed in terms of what's going on. But what I provided in that 6-page bibliography is some of the most leading edge discussions on those issues from a science and legal perspective. Taking issues in particular mentioned as well.
We'll have to have Clear not do the 1,000 pages, but they'll have to do the short version for us for our timeline.
6 pages is a short version of it.
Okay.
And of those, even of those, there's probably 10 documents that are really top of the line. But, there's a whole, they don't all say the same thing. That's the first thing to understand, because it depends on what watershed they've studied and what level of impervious cover that exists. We did that in Western Connecticut, where we have 30 to 40% impervious cover along the coast of Western Connecticut in our region. And it's not a coincidence that that's also where we have the most flooding. We've had $500 million worth of flooding since 1978 in Connecticut, and half of that is from New Haven westward to Greenwich. And that's the area where you have the most intense impervious cover in the state of Connecticut. These are not coincidences that we're seeing here. This is a question of where impervious cover drives so many issues, not just flooding or stormwater management, but water quality.
Bill Lucy, and I think you're our last speaker.
Sure, yeah, just to add to the resources we may want. I know the impervious cover layers are there from clear. The 303 impaired waters list is there. There's also to address the harmful algal bloom issue in lakes. There are maps, there are resources. I'll send a few to you, Casey. Or I know one good one. It's definitely a bigger problem in New York right now, but we have had HAB outbreaks in Connecticut, so there have been lakes in that situation. And there's also some of those occurring in Long Island Sound from time to time. So I offered to send it Casey's way.
Thank you very much. I can tell you where we were going to go on the field trip. I thought we would have time and we don't. So I can just tell you, and if you would like to go look at it, it's up to you. But if not, one of us can go video it and bring it back here and you can look at it. But Trout Brook in West Hartford, it's in the downtown area. It's more of a, it used to have trout in it, but now it's more of a flood control structure, and it's sandwiched in pretty good. But you can, if you go to the Norfeld, Norfeldt, Little League Field, you enter it from the Boulevard, near the corner of Boulevard, near the intersection of Boulevard and Trout Brook Drive. But you enter it from Boulevard, and there you can park at the playing field there and then walk along a Trout Brook Trail along the edge. You'll see there's areas where the buffer is not there, and then there are areas where it's been restored. And they just mowed down a whole section of it. And I was told by Amy from Farmington River Watershed that the city is required to mow it by a USDA agreement that was set up. And so whether they want to or not, they have to cut it right down to the grass level as part of their agreement. That's very old agreement.
Can I just mention, because I am familiar with this, that is in the Park River Regional Watershed. And, it's the operations and maintenance manual for the flood control channel that they have to clear that regularly. And we have actually, or I have approached, over the years, Army Corps and suggested that the operations and maintenance manual of be changed. We had a board member who was very upset about the mowing that went down along south of Beachland Park. And one of the problems with that is they not only mow, that they put pesticides, but they send like the Japanese knotweed. What happens is what grows up in between the mowing is invasives come in, and the Japanese knotweed that they've sent downstream has completely inundated the unchannelized portion south of Newfield within Hartford South Branch floodplain before that river is channelized and goes underground. So yeah, that's a big problem. And the other thing about the Trout Brook Trail along Trout Brook is that people often confuse that bicycle trail, which is within the section. I'm going to hold my hands up. The operations and maintenance manual is for the flood channel, which they have to routinely remove the sediment from the channel and then mow regularly. It's very costly for the city to do it's not a city, but the town of West Hartford to do that. So often the cost falls on the state, or it has in the past. But the other thing is that people confuse that bicycle trail, which is up, it's raised up because because it's on a flood channel with wanting to put a bicycle trail in the floodplain of the North Branch, which is undeveloped and unchannelized. So, you know, it's just an example of how each condition becomes very site specific with respect to the maintenance issues, the design issues, the historic design issues, and how the municipality has any funding or not to do a better job at maintenance. And if I may, I just want to point out that the issue of design could also mean innovation in the plants that are planted, and there's no support for that, and how we maintain things, because right now the maintenance of it is just mowing, and it's just leading to this outgrowth of invasives that they're just sending downstream regularly at the cost of taxpayers.
Thank you. And then if the segments go downstream, they can take root and grow somewhere else, correct?
Yeah, it's all over the. I've had people from deep tell me they've, or from I can't remember where, but tell me they've never seen so much knotweed, and that's all in the South Branch between the conduit entrance and Newfield, and that's all because it's being sent. It was sent downstream, you know, from other areas, and it's taken root all over the floodplain in Hartford.
So just like our meeting 2 weeks ago, I thought we didn't have enough material to, and we'd, and Mary, Representative Masiski thought we'd have time for a field trip. I could say we strayed from our agenda, but really we got a head start on next time, a really good one. I don't know if there's a consensus on our agenda item that the DEEP doesn't have the resources to expand their role much, you know, but we need to look at improving how we approach the training. Our next meeting, there's a time change. It's going to be at 1 p.m. on November 5th in the same location.
Thank you, everyone, for your time and effort. And Mr. Clerk, if we could invite Yukon Clear to come in for the first 20 minutes of our next meeting, that would be really helpful. And if they want to do it online, they can. They don't have to drive here. But we just need to hear from them. That would be important for everyone to be on the same level of understanding. Yep. Thank you. Thank you for coming. We'll see you next time.
Do we need a motion to adjourn? Motion to adjourn.
Okay, we have Alicia and Frank seconded it. All in favor? Aye.
Aye. I have a general question. If I can ask, can we share information with like my